Thank you, and for being here, and welcome. Thank you for those who are online as well, and a welcome to you too. We're here for the panel sponsored by the Genocide Studies Program and the MacMillan Center for Area and International Studies at Yale, with support from the Kempf Fund. This panel, the panel on pursuing justice for mass atrocities via universal jurisdiction, is part of what looks like will be a 3-panel series over the course of the next 3 or 4 months. We may add more, we sometimes do that, but a series called Developments in the Understanding of Genocide and Other Atrocities, although through international law. A future version iteration of this series will take a look at the developments through the ad hoc and hybrid tribunals. And then in January, we planned to sort of mark the first anniversary of the ICJ's judgment in South Africa v. Israel by looking back at the impact and implication of that decision in particular, but the use of the ICJ as a means of understanding the sort of genocide implications of a particular instance. So as much about jurisprudence as about the situation, but I think a useful way, honestly, to consider both. Today, though, the run of the show will be that I'll give a short introduction, brief bios of our 3 participants, 3 panelists. Then we'll hear from the panelists themselves, and then we'll have time for some Q&A, and that applies for online as well. I think the Q&A feature is online, so if you have questions that pop up, put them there. They will make their way to me as moderator of the Q&A session, and then we can you'll have your shot from afar as well. So our panelists. First up will be Hayley Evans. I'll introduce them all here, and then we can just have a more flow and conversation as they go. Hayley Evans, who will be joining us online, she is online, you see the picture here, but you'll see her picture shortly, is I think I have it right, 2019 graduate of Harvard Law and a research fellow at the Max Planck Foundation for International Peace and the Rule of Law. Her research focus has been on international humanitarian law, international human rights law, transitional justice, international criminal law, post-conflict governance, and law applicable to counterterrorism. Much of some of her recent work has looked at the applicability of these paradigms to Afghanistan. For our purposes, from a bit of a literature review on universal jurisdiction that I did, I found her work on sort of the understanding of universal jurisdiction and in recent developments to be some of the most thorough and I guess insightful background work that is out there. So Hayley will provide a sort of background, just what I suggested, where universal jurisdiction came from, but how its jurisprudence has developed generally and internationally up until this point in time. Then we have 2 panelists who are with us in the room today, Priya Pillai and Janine Giovanni. Priya is an international lawyer with over 2 decades of experience and is globally recognized for deep legal expertise in international law and advocacy. She leads the Asia Justice Coalition, focused on international justice and accountability, a coalition that has been key to efforts to hold the Burmese military accountable by supporting legal proceedings in international and domestic courts, including the use of universal jurisdiction. Previously, Priya worked at the UN International Criminal Tribunal for the former Yugoslavia, ICTY, and on global humanitarian issues at the International Federation of the Red Cross and Red Crescent Societies in Geneva. She has contributed her expertise to the International Panel for Pandemic Preparedness and Response, and as a judge at an International People's Tribunal for Ukraine on the crime of aggression. She is currently a World Fellow here at Yale. Janine Giovanni is Executive Director and CEO of the Reckoning Project, an organization dedicated to documenting war crimes in Ukraine and building cases for prosecution and international mechanisms. She's had an award-winning career as a war correspondent, authoring 9 books, including most recently The Vanishing, Faith, Loss, and the Twilight of Christianity in the Land of the Prophets, and The Morning They Came for Us, Dispatches from Syria. In 2020, the American Academy of the Arts and Letters awarded her its highest nonfiction prize, the Blake Dodd Prize, for her lifetime body of work. Currently, in addition to her position and I would say round the clock work with the Reckoning Project, Janine is a global affairs columnist at Foreign Policy and The National, based in Dubai, a contributing editor to Vanity Fair, and a board member of the Institute of War and Peace Reporting and Association of Foreign Press Correspondents. That's who you'll be hearing from. I'm really delighted that all 3 are able to join us. I think from this, we will get a very I hope, well-rounded view of what universal jurisdiction is and what it can and maybe can't do in cases of atrocity. And without further ado, I will turn it over to Hayley, who is live and online for the opening presentation.
Wonderful. Thank you so much, David, and thanks to Hira as well as the Genocide Studies Program and the MacMillan Center. It's really an honor for me to be with you all virtually today and to be on such an esteemed panel. So I'm really delighted to be able to share some research and just some kind of scene setting for the presentations to follow. So I have a short PowerPoint. So I'm going to share that. But as David has described, I will share some of my research on recent developments in universal jurisdiction. But mainly I will try to do some kind of background on what this concept is, both legally and factually, looking at the history of the concept, as well as then delving into some recent developments, both in terms of kind of the trends in which countries are actually prosecuting and the jurisdictions for the alleged commission of the international crimes that we're talking about. And then finally, I will speak to some issues and trends that we're seeing. A lot of these are issues that are not unique to universal jurisdiction, but are issues in the international criminal law project writ large. But hopefully that can get us thinking about some of these issues prior to our in-depth discussions on more specific cases. So first, to start with the legal background. The domestic prosecution of international crimes under universal jurisdiction is the prosecution of crimes that are committed outside of the territory of the prosecuting country. So typically we have jurisdiction on territorial basis or on a personal basis, meaning that there is a victim that is a national of the prosecuting country, or an alleged perpetrator is a national of the prosecuting country. Here we have jurisdiction simply based on the severity of the international crimes that were committed. And this is based on the idea that those crimes are so severe that they are of concern to humankind as a whole, and therefore they cannot go unpunished. So this is kind of an exception to the usual jurisdictional bases that we have. So there are a number of international conventions, including the Convention Against Torture, the Genocide Convention, the Geneva Conventions, that oblige state parties to criminalize certain conduct on a broad jurisdictional basis, and then either prosecute or extradite a suspect to a jurisdiction that can further prosecute. Scholars argue that under customary international law as well, states are either entitled or required to prosecute core international crimes. So these are the ones that were mentioned on the previous slide: genocide, crimes against humanity, and war crimes, also the crime of aggression. Due to the fact that those crimes are jus cogens norms, meaning that they are kind of the highest level of peremptory norm, like above all else, cannot be overruled without a subsequent, unless for a subsequent norm of the same international character. So we have all of these treaties, these international treaties, and states then are that are parties to these treaties are then kind of required to domestically incorporate or codify those norms. And there's a variety of ways that states have done this. So I've divided it into two kind of sections. The first is what is commonly discussed or called pure universal jurisdiction. This means that, you know, in principle, these countries can prosecute these grave breaches of international law, these core international crimes, with no other jurisdictional link apart from the crime itself. So they don't have to have a perpetrator be, for instance, German. They don't have to have a victim be German. They don't have to have the crime doesn't have to have occurred on German territory, but simply because the crime is so grave, Germany then is able to prosecute, for example. And so pure universal jurisdiction at the top is these countries that have codified the international norms in a very kind of all-encompassing way. This includes also countries like Bulgaria. Obviously, I have here Germany, Finland, and Sweden, Hungary, Poland, and others. Then we next have the group of most of the countries which have conditional universal jurisdiction. So whereas I have described the concept of universal jurisdiction as needing no links, these countries also kind of have incorporated that principle, but add slight links as well, or add slight conditions on the exercise of that. So once those conditions are met, they then exercise universal jurisdiction. So, for example, these countries might only focus on perpetrators that are in their country before they decide to exercise jurisdiction. They might also only decide to prosecute if other proceedings are not occurring somewhere else. So this is the principle of subsidiarity. Taking France, for example, one of the countries that has this kind of conditional universal jurisdiction. France has kind of famously had this idea of double criminality, which means that not only does the crime have to have been a crime at the time that it was committed in French domestic law, but also in the national context where that crime was committed. France also, in addition, requires that suspects must reside on French territory. And they have this principle of subsidiarity, that there must be an absence of proceedings before the International Criminal Court, for example. So this is kind of the two main buckets of criminal codes domestically into which universal jurisdiction falls. And now we'll move on a little bit into the history of how universal jurisdiction has developed. So factually, we first saw a universal jurisdiction law that was kind of the kinds that I have described in 1993 in Belgium. Belgium later used this law to prosecute a number of crimes that had occurred in Rwanda, for example. Next, kind of one of the most famous uses of universal jurisdiction is the 1998 UK arrest of the General Pinochet. So Pinochet was a Chilean military officer who was a dictator in Chile in the 70s through the 90s. So essentially a Spanish judge issued an international warrant for Pinochet's arrest. And after that, Pinochet was arrested in London 6 days later, and he was held on house arrest. So this is kind of famously the first time that universal jurisdiction was applied to a former head of state, notwithstanding also local amnesty laws that Chile had had at the time. So this is kind of seen as a big sea change in the existence of universal jurisdiction as a concept. Next, also in that same year, we had the International Criminal Court Rome Statute that was adopted and entered into force in 2002. So this is the International Criminal Court's governing statute. Essentially, under the Rome Statute, the Office of the Prosecutor of the ICC may investigate and prosecute for international crimes, the ones that I've mentioned before: genocide, crimes against humanity, war crimes, and the crimes against the crime of aggression. But this is only able to be done in situations where states are unwilling or unable to do so themselves. I'm going to go through these a bit more quickly now, but in 2002, also, German universal jurisdiction law was enacted. In the 2010s, there were a lot of French cases on the Rwandan genocide. In 2017, a lot of universal jurisdiction cases were initiated against suspects from Syria. And then famously in 2021, Anwar Raslan, a senior Syrian official, was convicted in Germany. And this was the first trial in the world for the abuses committed by the Bashar al-Assad government. And then a final kind of most recent development, not on universal jurisdiction itself, but in this same context, was the 2023 Ljubljana, the Hague Convention, which was a convention that was adopted on the international cooperation in investigating and prosecuting these types of crimes. So the actors that we're talking about here, not only are they domestic prosecutorial authorities, but also some domestic contexts have specialized war crimes units. So for example, France has an office for combating crimes against humanity, genocide, and war crimes. Germany also has one. The Netherlands has one as well. And then I've also included NGOs here because NGOs play a massive role in universal jurisdiction. They not only file complaints, but they also collaborate with and provide information to prosecuting authorities. They might provide support to the victims. They might also participate as civil parties. So NGOs have a massive role to play here. In terms of recent developments, I'm highlighting here a lot of the jurisdictions where universal jurisdiction cases are currently being lodged. So I don't imagine that this is entirely comprehensive, but to my best knowledge, these are the jurisdictions that have open cases. If you look at jurisdictions that can bring these sorts of cases, that's a much larger list. And I also want to note that this list doesn't include cases on the basis of active or passive personality, which is what I spoke about at the beginning when there's a suspect or an alleged perpetrator from that jurisdiction. So this is only limited to open cases of universal jurisdiction as of now. If we look at the jurisdictions of alleged commission, again, with similar or analogous caveats, we can see, I'll let you look at this list, but there are quite a few states here. And just to kind of give you a bit of a flavor for the types of situations that are being investigated, obviously there are situations where the crimes that I have mentioned have allegedly occurred. But as you might imagine, the crimes that are investigated in Syria focus on the Syrian government's alleged crimes against civilians, especially since March 2011. The ones in Iraq, for example, focus on Islamic State members for their alleged abuses against the Yazidis. Things of this nature, I think. A lot of them have to do with civil wars that have occurred or other government abuses, for example. So now to just bring up some issues and trends that we might want to think about. First is the existence of other domestic and international remedies and the idea of the fragmentation of the system. So ideally, core international crimes might be prosecuted in the country where they occurred. This is where the evidence can be found. This is where witnesses, victims, affected communities are able to engage the justice process. Similarly, states with personal jurisdiction, so linkage to the perpetrator or the victim, also might have better evidence and be more able to participate in that justice process. But at the same time, domestic jurisdictions might not actually exercise that jurisdiction if there's lack of political will, if there's political interference. There also might be lack of domestic capacity or resources to do so. And then on the last bullet I have here, international criminal court and hybrid courts, there might not be an ability to actually bring cases to the International Criminal Court. Taking again the Syrian context as an example, the Security Council can often be blocked from referring a case to the ICC. So this might be an example of somewhere we might want to think about pursuing cases under the principle of universal jurisdiction. Many say that universal jurisdiction is one tool in the toolbox, an important one, but just one. So there are other remedies or other avenues for justice that can be pursued. A second issue to just raise relates to the personal immunity of high state officials from prosecution before the courts of the prosecuting state. So as a matter of customary international law, foreign heads of state and certain other senior officials have traditionally been accorded immunity. This kind of preserves interstate comity and stability of international relations, but this becomes more questionable and more of a kind of a difficult issue when it comes to egregious violations of international human rights law and just international criminal law in general. So I'm sure everyone has probably heard about the Trump versus US domestic context of immunity and the distinction between functional and personal immunity. So functional immunity being immunity for acts performed kind of in the discharge of official duties, and personal immunity being both private and official acts. We do know from previous practice and from other sources that functional immunity doesn't preclude prosecutions of serious international crimes, but still states are adopting different positions on this issue. And as these contours still continue to be defined on the domestic level, this could remain an issue that alleged perpetrators might seek to exploit if they are a high-ranking official. And then kind of the last issue to raise is the idea of foreign policy implications and also the idea of sovereignty. So some critics have claimed that universal jurisdiction undermines national sovereignty and risks politicizing judicial proceedings. So this is kind of a conceptual criticism. Separately, when I did my own research of universal jurisdiction cases that have been occurring and looked at trends in which states prosecute crimes allegedly occurring in other countries, it had been interesting to examine this as, kind of an implication that, so basically I was looking at the colonial context. I noticed there was a recent Dutch arrest of a man suspected of war crimes in Suriname, French proceedings against a Syrian state official. The most judgments about Rwanda were done by Belgium. And so I was interested in the idea that these proceedings can be judicialized or can be kind of used as a tool of foreign policy. So who actually makes these decisions? Obviously, what I have just highlighted is an observation, and it's not, correlation does not imply causation. Clearly, there is a language similarity, also due to colonial kind of history that might have made it easier to prosecute for certain authorities in certain jurisdictions. But the idea of judicial imperialism is something that does kind of exist and is something worth noticing. And so finally, just to conclude, I think that universal jurisdiction is not a panacea, but I also do believe in this kind of idea of a toolbox. It can be wielded unequally. It can pose logistical challenges, including with accessibility of witnesses, things like that. But at the same time, when you do have situations where accountability is there's a vacuum for accountability and victims are not being heard and these crimes are going unpunished, it can be an extremely important tool in the toolbox, helping prevent impunity, holding perpetrators criminally liable, and helping prevent crimes of this nature from occurring in the future. So from my perspective, it is a welcome development in international law. Thank you so much. I really appreciate your time.
Thank you. Thank you very much, Hayley. That was wonderful. Really set the table nicely. I forgot to mention to everyone that Hayley is located in Germany, Heidelberg, right?
Yes, correct.
Heidelberg. Yeah. So it's 6 hours, 5 or 6 hours later there. Who knows at this time of the year? And really appreciate you logging on. And as I said, we'll save questions till the end. So hopefully, please stay with us. And I'll turn it over to Janine to Giovanni now.
Hello. So I'm coming from this at a very different perspective from Hayley. I'm the CEO of the Reckoning Project. We are a war crimes unit in Ukraine, soon to be in Darfur and Gaza. And basically, we are the people that Hayley described as the civil society that helped the prosecutors. But we also just launched our own universal jurisdiction in Argentina on torture against Russian individuals. As well, one of my team, who I'm very proud of, Raji Adel Salam, helped build the Koblenz War Crimes Tribunal in Germany in 2021. So I founded the Reckoning Project because I have reported and lived through 18 wars, including 3 genocides. In Srebrenica in Bosnia in 1995, I'd lived through the siege of Sarajevo, which was 1992 to 1995. So I witnessed horrific atrocities and war crimes. Second genocide was in 1994 in Rwanda, where 1 million people were slaughtered during a summer, and mainly with machetes. And I bring that up because to kill with a machete is labor intensive, very different from assassinating someone close up with a gun. Third was the Yazidi slaughter during the time of the Islamic State. And I spent a huge amount of time in Iraq, Kurdistan, Syria, the region. So my areas of expertise are mainly the Middle East, Africa, and the Balkans. I came into this world of investigating war crimes in Gaza, which was my first place that I worked way back during the first Intifada, which you probably weren't even born then, beginning in the late 80s, in 1987. My mentor was a human rights lawyer called Felicia Langer, who was she herself was a Holocaust survivor. She went to Israel and she became a lawyer late in life after the 1967 occupation. And she was one of the few Jewish lawyers defending Palestinians in military court. So you can imagine she lost nearly every case, and yet she kept going because she believed in the law and she believed in justice. So she basically gave me the mantra of, if you have the ability to go to these places, then you have an obligation. It's not even a choice. So my life's work has been investigating war crimes. That's what I do. A few days after the full-scale invasion of Ukraine, I got a call from a British academic who specializes in propaganda, Kremlin propaganda, Peter Pomerantsev. Some of you might have read his book. And together we founded the Reckoning Project. And basically it was based on work I had done at the United Nations, where I worked for several years in various capacities, that there was a gap in the justice system. For instance, the war in Yugoslavia, where I spent a huge amount of time, It took forever to get investigators on the ground after Srebrenica, but also after the Focha rape camps. There were rape camps established in the east part of the country, and I believe it was 16,000 women were raped over a period of time, some of them numerous times a day, with the intent to get them pregnant so that they would break the gene pool, the genetic pool. This was horrific. And only a handful, I think 24 men and women, actually went to The Hague for these crimes. I saw it over and over again in Syria, in Africa, in many places where I worked. That the perpetrators, it took so long to get investigators on the ground that the perpetrators would disappear. You know, they would disappear into villages, they would leave the country. In terms of, in the Syrian war, they would often go to France and disappear somewhere. The Iraqis as well would often go to Europe. In the Balkans, they would go into villages and resume new identities, as Radovan Karadzic, you may have studied him, who was the architect of the destruction of Bosnia. He was caught eventually, but it was many, many years later. I also knew that as someone that was often called by Hague investigators, they would call me sometimes 10, 15 years after an event happened. And they would say, you know, we need information about what happened in Mostar on April 10th, 1993. And I would tell them very honestly, if I didn't have my notebooks or my maps, I'd say, I don't remember. It was too long ago. So there was clearly a gap about getting to the site of the atrocity immediately and getting the evidence before it could be contaminated, and also getting to witnesses and getting the human, not just perspective, but the testimonies that could be used in court. But the thing we needed to do, while journalists are usually the best witnesses of this, journalists or let's say first responders, doctors who are on the ground, they don't necessarily know how to take legally binding testimonies which the prosecutors could use. And we know how tough prosecutors could be and would throw out evidence or testimonies. So what we do at the Reckoning Project is we only use locals because we believe it's very important. It gives them a sense of empowerment. When you're caught in a war and it's your own country, it's a horrifically, you feel powerless. You feel like there's very little you can do to affect change. This is something that gives them back some sense of empowerment over their justice system, but also that they're working to help their country. And the second thing is it's capacity building, because when I ran this program in Iraq and Syria and Yemen for the UN, what happened was that then the doctors I trained could go on to train other doctors, and it has a knock-on effect. So we started immediately after the invasion, and we trained beginning 20 Ukrainian. Most of them were highly skilled investigative journalists, but we had 5 or 6 lawyers on the research team. I have an entire legal division in my team of 5 lawyers, but I had lawyers working as researchers. Social workers are very, very good because they're great at interviewing. A few doctors, and mainly investigative journalists. So we trained them in IHL law, but we also trained them, very importantly, in trauma. So you cannot interview a traumatized witness. And this is the mistake often that journalists will make, because especially television journalists, they get to the scene of, let's say, a bombing at Kramatorsk train station, and they'll begin to go around with cameras and their microphones and, you know, what happened? How do you feel? All these questions, which are the wrong questions. So we train them how to take testimonies in trauma. Things, for example, like you cannot interview children, right? Journalists do this all the time. They will see a child, they will interview them. You probably see the images with Gaza now, like many of the Al Jazeera journalists, they're doing an amazing job, but they're interviewing kids. It's okay for a journalist to do that, but if you want your testimony to stand up, you can't do it. You need a law enforcement officer or a psychologist with you. And And then basically we get our witness statements, we archive them after verification, a very rigorous verification process, which uses OSINT, open source intelligence. We have a whole 5 people working on that. And then we help the prosecutors. So we're one of the few NGOs that are actually embedded within the Office of the Prosecutor General in Ukraine. I signed a memo of understanding in the spring with Andrei Kostin. And we help them. We like to say we try to be helpful. So for instance, we were given a year-long project by the German government to trace the missing Ukrainian children. Now, you may or may not know about this, but 19,000, we actually think it's much higher, Ukrainian kids were taken forcibly by Russian forces and sent to Ukraine to be adopted. So when they're adopted, this means their names have been changed. They can no longer speak Ukrainian, which is a very different language from Russian, by the way. They can't speak Ukrainian, they have to speak Russian. Their passports are taken away, and they're basically given a new identity. Now, most of them are very tiny, so they're 3, 4, 5, but some of them were young men, and they are also being forced to do military training so that they could fight in the Russian forces against their own country. So the Prosecutor General asked us to do a very specific thing to help with the case, which of course is at the ICC against Putin, to talk to the last people who were with these children. So most of these children were taken from orphanages. And many of them had special needs, so they were in centers for kids with disabilities. So we had 15 researchers working over a year throughout the country, largely in the occupied territories. So it's dangerous work. It's also dangerous for the witnesses. So we are very careful with our archive and transmitting any kind of data. That's one part of our work, the legal side of it. And I'll get to the universal jurisdiction case we built in Argentina, which opened in April. The other side is that we use our archives, which our lawyers let us, that won't contaminate or jeopardize any legal proceedings, for media content. And what do I mean about that? Because there's an enormous amount of propaganda and misinformation coming out of the Kremlin, flooding, well, you know how they affected the 2016 elections here, but largely flooding the global South. So the narrative of the Ukrainian war in the global South is not the same Ukrainian war that you're reading about in the Washington Post and the New York Times and the Times of London. It's very different. It's very pro-Putin. It's very much so that it is a NATO-led war, that it's a Western conspiracy. So what we do is fill content, write articles for the press and TV. We make documentaries based on our testimonies for the readers and viewers in Asia, in Latin America, and in Africa. And we travel throughout, kind of bringing this messaging. So this is what we are. Like, we are a nexus between journalism and the law. We pursue accountability through fact, through rigorous legal standards. And we have deployed universal jurisdiction as a strategy to communicate important messages on both legal and journalistic fronts. That was the message from my chief legal counsel. He wanted me to read that. Being mindful of the geopolitical dynamics at play in our choice of domestic courts, especially in regards to the global South. So I just want to point out, why do we choose Argentina? Because a lot of people say to me, why Argentina? Several reasons, and we went through the map of where we could bring. It would have been a lot easier to do it in Germany or France, for instance, but in fact, Argentina has consistently voted what we see on the right side of Ukraine. They have a history of their own terrible, dirty war. Our case is on torture, so they have a long-standing history on that. But they've also had successes with the universal jurisdiction for the Rohingya people in Myanmar, and also against the odious Mohammed bin Salman for his crimes in Yemen, Saudi crimes in Yemen. So we chose to go to Argentina. We brought our witness, who I can't name him, let's call him Mr. X. We brought him from the Kherson region of Ukraine to Buenos Aires. The selection process was interesting because we had 80 people we could have chosen from. And we chose him for many reasons, but mainly because he filled he ticked all the boxes. He was willing to travel. It's, men can't leave Ukraine. So we got a special exemption to get him to leave. He was willing to talk. And his story, we felt he could give a human story, which we could play into with the Argentinian press. And we laid the groundwork long before we went there with him by activating actors on the ground. So universities, journalists, experts, academics, we made them all aware of what we were doing. We see universal jurisdiction. I mean, I'm asked this all the time, but it doesn't do anything, does it? You're not actually going to get Putin. For us, it's more than symbolic. And for me personally, having spent a lifetime, 35 years now, consistently seeing the bad guys get away with it, and then me having to go back and see the people I've interviewed or I've taken testimony from and them saying, I'm never going to get justice, am I? My family was murdered, my house was burnt down, but no one's ever going to go to court for this. We feel that it sends a very strong message that justice does work, that it is at play, and that more importantly, that people are watching it. So it is more than symbolism. And we're going to be going to Gaza, as many of you know, very, very, very difficult to work there. But the question that I've heard for so many years from people in Gaza that I would talk to was, will anyone ever be held accountable? And accountability is so hugely important in post-war. And I always look at, I'm a conflict analyst by training, so I look at two things. How do wars start? And that's terrifying because you look at basically the indicators of how wars begin. They begin very quickly, by the way. 1 minute you live a very normal life, and the next minute everything shuts down. And how they end. Hugely important that wars end in a way that new wars will not start. And I know I don't have a lot of time, so I'll wrap up. But for instance, a war that ended very badly was Bosnia. The 1994 Dayton Peace Accords rewarded the perpetrators. It did not reward the victims. There was very little justice after that. I know my friends from the ICJ, the International Court of the former Yugoslavia, would argue that. But to me, I work on the ground. I work with the survivors of Srebrenica. I work with the rape victims. I work with these people. And to them, it was justice delayed, and basically to them, justice denied. So it's important to send a really strong message that impunity can be crushed, and that accountability is at play. I'll leave it at that because I know Priya has got some interesting things to talk about, but basically the real difference with us is that we're on the ground working, as David said, 24 hours. Thank you.
Thank you very much, Janine. And again, just a reminder, if you're online, you can type in questions in the Q&A feature, and we will get to them after Priya Pillai's talk. So Priya, please.
How are we doing on time?
Thank you very much. Good afternoon. Thank you all for coming. I'm really glad to see you because I think this is a really important discussion, and I'm glad that we've had, technical sort of laying the groundwork by Hayley, and then Janine sort of really talking about what this means at a personal level and why this is critically important. So let me step back a little bit. I'll just tell you a little bit about what I'm doing as the head of the Asia Justice Coalition and the way that we've looked at universal jurisdiction as one of these options in the toolkit of international justice and accountability. So To the point that's been made before, you've got these cases now that are, being litigated across Europe. So you've got cases that are ongoing in Netherlands, in Switzerland, in Germany, in France, linked to Yemen, Libya, Syria, multiple jurisdictions that have been the origin of these atrocities. And this has gained ground in the last 10 or 15 years. And I would highly recommend, Hayley put up the names of a lot of organizations that are doing work. They actually come out with a publication called the Universal Jurisdiction Annual Review. It comes out every year, which is a fantastic resource. It's one page on every case that is being litigated across the world and what stage that case is at. So you get a snapshot, and there's a great infographic in the report as well, which will give you a snapshot of, how many perpetrators are being prosecuted, where are these cases ongoing, and what is the stage of the case. So just to say that there seem to be a lot of cases in the global north, in Europe, essentially. And that led me to ask the question, why are there not more of these cases in the global south? Is it that the conditions are not right? Is it that the legal environment is not right? Like, what is it that we're missing? And why can we not have some of these cases being initiated in other countries as well? I think one of the sort of proxies in a way, and I think, look at it as an international criminal law ecosystem. So you've got the International Criminal Court, you've got some ad hoc tribunals or specialized courts that are set up for a specific situation. For example, the ICTR for Rwanda, the ICTY for Yugoslavia. And then you also have domestic courts that do talk about or do prosecute international crimes. So in the scheme of this ecosystem, where is the global south on universal jurisdiction specifically? And for me, I was really curious about the Asia Pacific. That is the region we focus on. So I wanted to look at what has been done. And the immediate response when I would ask the question to say, why are there no cases here? And has anyone looked at it? The immediate response would be, no, it's not possible. But when I would follow up and say, why? I never got a clear answer. Nobody really seemed to have done the groundwork or the research. So all that to say, we decided to take this really seriously a few years ago. We got together different groups of civil society organizations, prosecutors, academics, people who are working on these cases across the world, including in jurisdictions in Europe as well, to actually talk about what it takes to have these cases. We had 3 convenings, which basically were closed door gatherings across 3 days of people who were doing these different sort of types of work across different regions. So we talked about avenues to accountability, universal jurisdiction in Asia. We talked about universal jurisdiction in the global south, reviewing and reframing some of the questions. We talked about barriers and opportunities and the role of civil society in supporting prosecutors, in supporting the entire sort of ecosystem of these cases and what it took. And that was quite instructive because we realized that a lot of civil society organizations were doing the bulk of the work. They were coordinating with witnesses, they were trying to safeguard witnesses, they were actually collecting evidence, and then they were essentially helping prosecutorial services, across these countries or war crimes units with some of the information and trying to get these cases to move forward. In terms of what we're doing specifically, we've looked at 9 countries. So we've worked with law firms across the region, and we have 9 country briefs that are coming out. These essentially are to look at what is the ecosystem in each of these countries in the Asia Pacific to see whether there might be a legal hook. There might be some way, some obscure clause in some, legal text that might allow us an into sort of some of these cases and sort of moving forward. So the jurisdictions we're looking at are Korea, Japan, Singapore, Thailand, Malaysia, Indonesia, Sri Lanka, India, and Bangladesh. We have 3 jurisdictional briefs that are out already. So if you look at our website, you will find these briefs, but the rest should be out by the end of the year. In terms of the Asia Pacific region, I think the proxy is, if you look at the International Criminal Court. So the International Criminal Court founding document is the Rome Statute, and states sign up to the statute. Asia Pacific has the lowest rates of ratification. There are 19 states compared to the Americas, compared to Europe. So we're really lagging behind. And usually what would happen is if you have signed onto the Rome Statute, it would invariably mean that that is what you would use to domesticate it. You would incorporate that into your national law. And so then you would have a way to actually prosecute these international crimes, whether they occur in your territory or whether they occur in somebody else's territory. So that's a good proxy. That's a good rule of thumb to look at. But that's not to say that there might be other provisions in other laws that we just don't know about. So which is why we're really doing a lot of this groundwork. And in the next year or so, we should then have a clearer picture as well on the Asia Pacific as an option to pursue some of these cases. I'll come specifically to and so just to let you know that we've also done a lot of work, and our focus really setting up the Asia Justice Coalition was on Myanmar, on Burma. And we've supported some of the work around the ICJ case, the ICC case, but also very specifically the universal jurisdiction case in Argentina. So one of our members of the coalition is called the Burmese Rohingya Organization UK, Brooke, headed by a gentleman called Tunkin, and they have been at the forefront of this case. And we've really been supporting them for the last few years. So I'll tell you a little bit about the case, why Argentina, how did this come about? I mean, and I think just for me, this 1 week in November 2019 was really an instructive and a very crazy week. This was the week in which the International Criminal Court announced it was opening, examining the situation in Bangladesh and Myanmar. The International Court of Justice application by the Gambia was instituted that week. And at the end of the week, the universal jurisdiction case in Argentina for Myanmar became public as well. So November 2019 was quite a watershed moment for Myanmar and for what sort of the developments around international justice and accountability for the Burmese context specifically. But coming specifically to this case, this particular case in Argentina right now, keep in mind, we're talking about November 2019. So this is before, and just to give you all a little bit of information on what's happening in Myanmar, there was a coup in 2021. So 2019, this is a response to mass atrocities against a minority in Myanmar called the Rohingya, who were subject to what is euphemistically called clearance operations. Essentially the Myanmar military burning down villages and committing mass atrocities against the Rohingya. So in August 2017, about 800 to 900,000 people fled their villages and crossed the border into Bangladesh in the space of a week and a half, 2 weeks, and really unspeakable atrocities. And this case was in response to these atrocities. So we're not really talking about the coup, we're talking about what had happened before the coup. And that's important because this was essentially a complaint that was brought in the courts of Argentina linked to crimes against humanity, as well as genocide perpetrated against the Rohingya, so against a specific community in Myanmar. And I think it's important to sort of also understand Argentina and understand why Argentina was one of the options. And there are many factors, not least of which was the fact that Argentina had its own history, had its military dictatorship, had a deep experience of what it took to try to gain justice and accountability for these crimes. But also it had a series of cases linked to Franco and Spain that were being litigated in the Argentine courts as well. So it wasn't just that the system understood what to do domestically, but the legal system was also geared towards atrocity crimes that had occurred in other jurisdictions. And so this was incorporated into the domestic law, into the constitution, into the criminal code as well, which gave it sort of that extra knowledge and sort of ability to deal with a universal jurisdiction case thousands of miles across the other side of the world, right? Really no connection between Myanmar and Argentina, which is also always a question that is asked. So I'll tell you a little bit about what happened and what has happened with this case, and a few lessons maybe that we can draw from that. So this was initiated in Argentina in 2019, and this was linked to crimes against humanity and genocide. Essentially, the legal basis was Article 118 of the Argentine Constitution, as well as a law which was enacted to implement the Rome Statute. So again, the link to the Rome Statute comes into play quite strongly here. And the sort of the temporal frame for this was that the court should look at crimes committed between 2012 and 2018. So till the time that the Rohingya were essentially expelled across the border into Myanmar, into Bangladesh, my apologies. Well, the course of justice does not run smooth. The case was initiated in December, and it was in November 2019, and it was rejected at the first instance in December 2019. And it's really interesting. One of the reasons why the court was reluctant to look at it was because of another court, because the International Criminal Court had already initiated its investigation and was looking into what had happened across the border between Bangladesh and Myanmar. And so the court, the chamber first instance in Argentina was very reluctant. The judges basically said, well, there is an international criminal court looking at this. Why should we step in? What is our standing? Is this really necessary? And essentially arguing that it would duplicate the investigation by the International Criminal Court. This went on appeal, and in 2020, this was overturned by a federal chamber, which basically said, we sort of reject the premise of the first chamber, and we think this case should move forward. But what is also really interesting is that this chamber then actually reached out to the International Criminal Court and said, we need assurance from the ICC that what we are doing does not conflict with what the ICC is doing. We need assurance from the Ministry of Foreign Affairs in Argentina that these are separate, distinct proceedings as well, before there's a final decision on moving forward. That was then granted in November 2021. So the chamber was convinced that, yes, these are distinct proceedings, let's move forward. And essentially what the court did say was that we need to see some sort of a link. We need to see a real and direct harm. So we need to see that the complainant or whoever comes to court has suffered some of these harms. So in this context, the head of the organization, Brooke, actually went to Argentina, testified before the chambers, before the judges, and subsequently in 2023, there were 6 women from the Rohingya community who also testified before the chambers on sexual and gender-based violence that they had suffered, because the court wanted to see that there was this link before moving forward. So the case is right now ongoing. I gather that there is, that we're hoping that there will be arrest warrants issued soon. But of course, I don't have any clarity on the timelines for this. A few things that I will highlight from this case, and I think that are really important. One is the role of individuals and civil society. So the first, of course, is that Brooke initiated and spearheaded this case, but they didn't do it alone. They really did it with the help of organizations in Argentina. So you had the grandmothers of the Plaza de Mayo, who had been advocating for justice for over 30 years. They actually supported Brooke in navigating the Argentine legal system, as well as the Foundation for Peace and Justice. So I think you can't underestimate the importance or the value of local organizations as well, and what they know of the legal system and how they can support you. And the other really important point, I think, especially for this case, was the fact that there was a counsel in Argentina called Thomas Quintana, who's an Argentinian human rights lawyer, who had been the UN Special Rapporteur for Myanmar for years, from 2008 to 2014. So he was intimately sort of aware of what was happening in Myanmar, but also really knew what was happening in the Argentine legal system. So he could navigate both of these areas. So I think that was really critical. So sometimes it comes down to people. It comes down to personalities and individuals, and it's a matter of timing as well. So I think just a few highlights from this case. It really has been the first universal jurisdiction in relation to Myanmar in Argentina and any other jurisdiction. The capacity of the complainant was important for the court in terms of having real and direct harm and being able to prove that. There was no territorial nexus required. As Hayley had mentioned, there are some sort of approaches which are conditional, where you need some link. You need either territory link or you need a link with the perpetrator. Here, that was not necessary. But of course, the prior history of Argentina, I think, is critical. And last but not the least, and I think this is going to come up a lot more as this international ecosystem develops, the relationship between different legal proceedings in different fora. So what's happening at the International Criminal Court versus what's happening in Argentina, also what's happening at the ICJ, what are the points of contact, what are the, how do we view these different fora, but more important, how do these courts view their role, and how do they see sort of how they limit their role, and that so that they are not stepping on the toes potentially of another court. So I think these are a few of the issues that came up in the context of the Argentina Myanmar case. I'll make one or two comments just in terms of where things are on universal jurisdiction as well. Hayley did mention the mutual legal assistance treaty negotiations in Ljubljana. And I was in Ljubljana for 2 weeks last year in May over the negotiations. A small group of civil society were there. And we actually played quite an active role because per the rules, we were allowed to be in the working groups, we were allowed to be in the plenary, so we could actually work with states and sort of negotiate some of these terms. And it was really fascinating because one of the sticking points in the negotiations was the obligation to extradite or prosecute. And we actually had states in the room that wanted to dilute these obligations, especially the states that are dealing with universal jurisdiction cases. I think the load and the pressure of these UJ cases now has become quite overwhelming for many states, including Germany, including France. And so you do see a pushback. And we saw that play out in the negotiating rooms over those 2 weeks very clearly, that the pendulum has swung perhaps too far according to some states, and now there's a concerted effort to actually push back and to stop this flood of universal jurisdiction cases. So I think we're at a quite a pivotal, interesting moment as well in the development of the law. But I think more than anything else, to Janine's point, it's really about the survivor communities and what they get out of these proceedings, that they need to get a form of justice and accountability, and how that translates is also critical. And I think also not sort of having false expectations or being realistic about the limits of some of these cases and what the challenges, and there are many challenges. So this has been going on for quite some time. It's usually a process that takes a few years. And so it's not easy, it's not simple, and it's not quick. And I think messaging some of that is also really important. So I'll stop with that. Thank you very much.
Thank you very much. Excuse me. Thank you very much, Priya. Maybe the two of you will sit up front here, and we'll just know that Hayley is on there. So it's question. We have a few minutes for questions and answers. So I will invite any such that might arise. Yeah, please. Let me pass the microphone around just so that people online can hear you.
Thank you so much, the three of you. I just wonder that is something also that Priya mentioned. Also, you mentioned that Argentina, right, as the heart of this international jurisdiction, how much did it play the way that they handle their own issues and impunity during the Argentinian dictatorship? And on regard to that, I would also suggest or recommend the audience to watch 1985. That is a great movie. And also, if you're a student if you're a student and studying law, you could see that part of Argentinian history was key, and the students, not even lawyers yet, they were a key and pivotal element to define this. Just I wanted to understand more all this.
I think you're asking a question of how Argentina dealt with its own, with the past, with the dirty war. So I have to say, of course, I know a bit about the dirty war, but my expertise is the Middle East and the Balkans. So I can't, but I could talk more broadly about memorialization and transitional justice, if that would help you. But I think, would you like to speak directly on Argentina?
Yeah. Just a bit. I mean, and thanks, Gonzo, for that. I think Argentina's own internal experience, exactly to your point, essentially forced Argentina to confront its past. 40 years of the grandmothers really advocating and pushing for justice. And what happened as well is that that resulted in a constitution that recognized these crimes as international crimes, that ended up with Argentine state basically saying, yes, we will sign this Rome Statute, which sets up the International Criminal Court. So really demonstrating a real commitment to not have this repeated in other places and to make sure that it was incorporated in theirs. And so that's why I think it is really become a key jurisdiction in a way to look at, because it has these strong legal provisions as well, but it has strong political and historical reasons why they would take this very seriously and would not sort of dismiss it as, you know, something that they can't deal with. So, yeah.
Let me jump. There's a bunch of questions online, and I would actually love to hear you talk about memorialization, because I know you have a lot of interesting things to say, but I think in fairness to the folks who've asked questions online, maybe find a way to circle back to them perhaps, because I think it may well come up again. One question online is, I won't say names online unless explicitly given permission to do so. We have seen some countries that have refused to extradite or prosecute suspected perpetrators of genocide in the Rwandan context. Could you elaborate on the issue, I assume extradition in particular, and discuss its implications for universal jurisdiction? And Hayley, just give a wave if you want to chime in on one of these questions. Extradition. Hayley, how does when you brought up the I'm forgetting which case, but the Pinochet case, there was a question. Yeah, the question of extradition. That he was arrested in Britain 8 days after the Spanish warrant. So clearly, Britain thought it had an obligation to arrest in light, of its extradition arrangement, maybe as part of the EU. Well, no, this is I won't weigh in on EU history there. Anyways, if you could maybe address this, the intricacies of extradition in this context.
Sure. So at the time, I think that the Pinochet case is a little bit unique. Well, maybe actually not unique. So one of the issues in this case was actually how he was aging. So he had health conditions that are actually what prevented the UK in the end from extraditing to Spain. So there's this idea of perpetrators kind of aging out of criminal liability, because when we're talking about universal jurisdiction, as the previous panelists have stated, like we're talking about things that might have occurred years in the past in other jurisdictions that are far away. Evidence takes a lot of time, cases take a lot of time, and so you can run into this issue of actually becoming immune in a way because you're aging out. So there were health concerns in this case, which prevented General Pinochet from being extradited to Spain. But he was there was then later a case as well. So I would say that is one thing to note, but a lot of political considerations can obviously also come into play when it comes to issues of extradition.
Just to add to Hayley's point, I mean, I think just conceptually on the obligation to extradite or prosecute, essentially the aim is that there should be no safe haven. So either you prosecute, and if you do not or cannot prosecute, you extradite to a place that that person can be prosecuted. And this has become a key part of not just recent treaties. So the MLA, which was negotiated in Ljubljana, that was a key provision. Right now in the 6th committee, there's a final discussion on a Crimes Against Humanity treaty, which hopefully we're hoping in the next few weeks we will know that it moves forward into treaty negotiations. And that is again a part of sort of the provision of the draft treaty. So it's become a really important norm. And I think this is something that we need to keep in mind, that essentially the idea is no safe haven.
So just, perpetrators will use incredibly creative means to disappear or to hide. And I remind you of Radovan Karadzic, who basically disappeared into a Serbian village and reinvented himself as a new age practitioner of hypnotherapy. And this was a man who was a psychiatrist who had basically, led to the destruction of Bosnia. He was caught eventually through a series. I mean, some of us were working for years trying to track him and to track Ratko Mladic. And, as time went on, they were getting older, but the witnesses were getting older. And and this is why the Reckoning Project, we do our work immediately, because one thing that also happens is witnesses who might speak to you initially will get spooked as time goes on, and their memories. We all have memory lapses, and also in terms of trauma, the way that they remember things becomes more and more convoluted. So that's why, I think also going back to my earlier point, which is time is of the essence when you're investigating atrocities.
Okay, thank you, all three of you. I'm going to take another question from online, which is, it's actually a fairly long question that took up two emails, so I'm going to paraphrase with my apologies to the questioner. Very thoughtful question, I should add. And it starts with the point that genocides and atrocities don't happen in a global vacuum, but they happen with the somewhere between permission and failure to act or respond or prevent on the part of neighbors and the global community in either a specific or general sense. Does universal jurisdiction provide a means of holding those who are responsible for those failures to account? This is one of the ones, if I'd asked it on a test, a midterm, everyone would be like, that's the question. The look on your face is like, there's an answer for this. No, that's my well, yes, it is actually. The students in my class later today will be expecting something like that, perhaps. But no, that was my paraphrase of a question online.
I can add
I can tackle it a little bit, and then maybe Hayley and Janine can add in. So essentially, you're talking about the obligation to prevent, or then you're talking about if something has already happened, if there's already been commission, you're talking about incitement, you're talking about the other inchoate crimes, right? Complicity, exactly. So that would essentially really depend. If you're looking at a universal jurisdiction case specifically, you would then look at the country where you're prosecuting the person. So you would look at the law, for example, in Germany, or you would look at the law in Argentina, and then you would say, okay, does the law provide for incitement? Does it provide for any of these modes of commission? And that would be your route to saying, okay, in this particular case, it's a universal jurisdiction case, that it would address some of these harms. It may be different in another country. So it really would depend. And I think that is the complexity about discussing universal jurisdiction as a concept, which is, I think that's the complexity with universal jurisdiction, that it really depends. It's very country and jurisdiction specific, unlike the International Criminal Court or the ICJ, which have sort of a statute that sort of is the statute for that court. So universal jurisdiction, I think we've got very different, which is why you can actually forum shop a little bit, depending on where the law is more amenable to prosecuting certain types of crimes.
And I guess I would like to speak a little bit more generally about complicity, because I think it's such an important topic in our world of atrocities and war crimes. When you were talking, David, when you read that question, all I kept thinking was the United States and Iraq, and I couldn't, and Afghanistan, Afghanistan just completely bypassed now. And the number of times that I'm asked in my work, will the US ever be held accountable for Raid, for Guantanamo, for the countless crimes, or for the crimes against civilians in Iraq? And I went through the entire war in Iraq. I worked there in the Saddam times. I worked there during the fall of Saddam, and I worked in the aftermath, the surge, and the terrible time of the insurrections. And I remember US military going literally 3 cases cash to pay off families who had been the victims of US bombing. And people would say to me, the US, will they ever be tried in an international court? So, I mean, that's my first thought. And my second thought is that there are ways, for instance, let's look at a difficult topic and a sensitive topic, Gaza right now. Antonio Guterres's line that it didn't start October 7th, it didn't happen in a vacuum. There were numerous, of course, going back to 1947, that led up to what happened on October 7th. Not excusing it, but so can we begin to look at issues like the US and German government's complicity in aiding and abetting what is now looking to be more and more a genocide in Gaza? And I think it's really important. I mean, we're not really allowed to say that out loud, especially with the German government, because there's such deep sensitivities with their very dark past. But, to what extent do their bombs ignite Al-Aqsa Hospital, or the death march from Jabalia refugee camp last week, or starvation as a tool of war? Okay, so who is aiding and abetting that? And I'm afraid there's times when I'm ashamed to hold an American passport. And I think this is how people felt during the Vietnam War, that it was an incredibly painful experience to know that your government is sending bombs that are killing people, civilians. So that's slightly off topic, but yet it is the broader topic of complicity, which is what we really hope to work on with, going after the perpetrators.
But in some ways, it's particularly relevant because for this discussion of universal jurisdiction, because UJ is this realm of addressing this avenue for addressing alleged crimes that are very unlikely to be addressed in other jurisdictions.
More creative.
And so, yeah, there's this whole creative realm of finding jurisdictions that may or may not hear this case. Now, that has we can cast that as an opportunity, we can cast it as a downside, which is to say, well, does that mean anything can be tried and heard anywhere without any sort of catch or guard for the quality of the trial? And maybe, I don't know if the Ludmana Accord sort of was trying to address that issue of, hey, this might be in your realm as well. Like what stop guards to sort of UJ abuse are there? Not to say that we are proposing would be an abuse, but the reaction would be, well, if we do, there's this deluge that's coming, and quality will go down.
Speaking of the
Go for it.
Yeah, thank you. So I guess we've had now a couple of different points. One is kind of on prevention and what individual states might do to prevent within their own borders. Alongside that, there's also obviously the idea of the responsibility to protect. This gets into also kind of use ad bellum issues and the idea of self-defense in a global sense, kind of the state idea of anticipatory self-defense and the responsibility to protect. So whether a state is able to go into another state in order to prevent genocide, for example, from happening. But then also on the issue of kind of complicity and what we can do there. There are cases, I'm thinking in particular of a European Court of Human Rights case in which Germany was, there was a case pertaining to Germany and its operations in Afghanistan, and whether or not the procedural limb, so there's basically in the right to life as codified in the European Convention on Human Rights, there are kind of two limbs, and one of the ideas is that an investigation this is also just a general norm in international law, but a proper investigation must be must take place into a death. And there was an airstrike in Afghanistan, and the idea was that maybe Germany had not properly investigated this airstrike domestically. And so this case was brought to the European Court of Human Rights. So there are other avenues that exist for investigating. This is just one example, but there are other avenues that do exist for investigating states that don't have to just be places that are so politically, or venues that are so politically captured. And a lot of them clearly are. So those are just some additional kind of thoughts that made me have.
Great. Thank you. Thank you, Hayley. We've actually,
It's broken, or it's dead. The battery's dead.
oh, that's right. I forgot about that. Yeah, I thought maybe we'd magically just letting it rest. We're sort of at the very edge of our time, but let's take one last question from the room, and then we'll wrap it up.
Thank you. I'm Jonathan Fanton, and when I was president of the MacArthur Foundation, we put money into the goal of creating an international system of justice, and we put up some of the initial money before the states parties had the money in to actually get the ICC going. Therefore I had lots of interaction with people, including Campo, the first prosecutor. And, I have to say that what's happened since is not as good as what we'd hoped. Doesn't mean I'm against the criminal court, but I am a little disappointed that it hasn't been more. Another thing we did at the request of then Secretary General Kofi Annan, and I put the money into this as well, was to put together a need for a commission outside the UN to look at the tension between state sovereignty and humanitarian intervention. And that was co-chaired by Gareth Evans of Australia, and totally outside the UN, but sort of Kofi's blessing. And we came up with the concept of the responsibility to protect, which he brought to the General Assembly, I think in 2005, and it was endorsed. So it was kind of official UN policy. And ask yourself, we just heard the words a moment ago, but ask yourself how often heard the term responsibility to protect in Gaza, Ukraine, Sudan. There are many, many situations around the world. And yet the concept is, I'm afraid, pretty well dead. And I think the critical blow is when it was cited as a rationale for European intervention. But all from the very beginning, the hope of establishing an international system of justice and the court was prevention, not just prosecution and punishment. And the responsibility to protect is a very important part of that larger conception. So there's work to do. You can't give up on it. Really enjoyed the presentation.
Thanks very much. And I let me just take that specific responses on R2P, because my students here that are in this session know I fixated on that subject a lot myself, and there's this interesting interplay between international institutions and recognition of sovereign responsibility that is at the heart of the universal jurisdiction debate or movement as well. And I think, I would like to hope that you're wrong, that it's dead, that the concept of R2P is dead. I think that there's room and space to revive it. And I think the process of the development of these norms is decidedly nonlinear. And I think that's the same with universal jurisdiction. If the net process is nonlinear, it doesn't mean that the advocacy doesn't need to be constant, and advocacy for better versions of all of these things. And so I think that that's where where we are now. I'd like to thank, in that respect, if I could segue into an expression of gratitude, all three of our panelists, Janine, Priya, and Hayley, for their presentations here today, but also, to pivot off that last point, for being that part of that constant presence and pressure and force in really very different ways, but also something really part of the same movement in some essence as well.
Ecosystem.
Ecosystem, there's the word. Yes, thank you. I've been,
We were using that.
So thanks for both. Thank you all for coming. Thanks for those online. My apologies to those who didn't, whose questions I didn't quite get to. I appreciate, by the way, there were people from Purdue and people from Washington, D.C. and from Rwanda. So we had something of a global reach with this little event. I'm grateful for those of you online who joined that. Additional thanks to Hira Jaffrey and her office for all the organization that went into this. And a heads up, that next, it's not a genocide studies program panel, but it's going to be on a genocide studies subject, and I don't mind promoting it at all. I encourage you, accountability for forgotten crises, with Priya, Pillai, among others. Next November 8th, that's next, not this Friday, but next Friday, 12 o'clock in SLB 120. What is SLB? Sterling Law Building. Okay, in the Law Building, room 120. Moderated by Professor Claudia Flores and organized by him. So if you have questions, keep your, if you're not on our mailing list, please, I encourage you to go to our webpage, the Genocide Studies Yale, and sign up for a mailing list. You'll find out more about the next two events, at least within this panel series. Thanks again and have a great day.